Hello everyone, I am Anuj Nakade and you're watching Live Law. On Monday, the 14th of August, the Supreme Court expressed concerns about the ineffectiveness of the self-regulatory mechanism set up by the News Broadcasters and Digital Association. These concerns were expressed by the Supreme Court while hearing a plea filed by the NBDA against the critical observations made by the Bombay High Court while deciding a PIL against the media trial in the case of Sushant Singh Rajput's death. In this judgment, the Bombay High Court had observed that the media ought to avoid discussions and debates relating to criminal investigations and should confine themselves to informative reports, and issued guidelines for reporting the ongoing investigations in the future. The Bombay High Court had shown serious lack of confidence in the self-regulatory mechanism established here, saying, and I quote, "In our opinion, such self-regulatory mechanism would hardly meet the constitutional expectations of the citizens of a fair and responsible broadcasting, which would be of a nature of unwarranted sensitization, excessive publicity, leakage of evidence, and vilifying coverage affecting public confidence in the judicial system and in the administration of criminal justice." A three-judge bench of Chief Justice D.Y. Chandrachud, Justice J.B. Pardiwala and Justice Manoj Misra heard the plea filed by the NBDA against these observations. Senior advocate Arvind Datar appeared for the NBDA and argued that the High Court's assertion that the self-regulatory mechanism lacks sanctity within the statutory framework is flawed. He emphasized that while the NBDA acknowledges it is not a statutory body, it opposes the adverse remarks made by the High Court that question its credibility and effectiveness. His contention was that the self-regulatory body functions similarly to an alternate dispute resolution mechanism. His exact words were, and I quote, "This started during the Sushant Singh Rajput matter. There was a media frenzy. PILs were filed against media trials, and that is where the matter was filed. The remarks of the Bombay High Court had a damaging impact on the integrity of our body. The scheme of the law is that TV channels should be left to be regulated by themselves. The state is not supposed to regulate." He also pointed out to the court that the authority has disposed of 4,000 complaints. In many cases, the media channels in violation of the NBDA standards were asked to publicly apologize for their conduct in addition to the monetary penalties. In response, the CJI expressed concerns about the efficacy of the self-regulatory mechanism, particularly in cases where the media coverage potentially hampers criminal investigations or tarnishes one's reputation. He said, and I quote, "Mr. Datar, you say that barring a few channels, all media channels exercise self-restraint. I don't know if you can take a head count of people in this court who would agree with this. We understand that you don't want the government to intervene and you want the self-regulatory mechanism to continue. Equally, the self-regulatory mechanism is to be made effective." The CJI also said that the media went berserk after the actor's death and created a frenzy. Questioning the amount of the penalties imposed on channels who violate the standard, he said, and I quote, "A fine of ₹1 lakh for a channel, is that really effective? Your fine must be proportioned to profits you make from that show." Finally, the CJI added that while the NBDSA, or the News Broadcasters and Digital Standards Authority, the self-regulatory framework, is hearded by former Supreme Court judges, their remit is limited by the NBDA's guidelines. At this point, Advocate Amit Pai, appearing for certain party respondents, also underlined the ineffectiveness of self-regulatory mechanism by the NBA. He said, and I quote, "Earlier there was an instance of a TV channel I don't want to name, but the reality is when the NBA imposed a penalty of ₹1 lakh, they left the membership of the association and joined another one." The bench then urged that there was a need to strengthen the self-regulatory mechanism and emphasized the need to reconsider the penalty structure, which has remained unchanged since 2008. The court said, and I quote, "We have seen the uplinking and downlinking guidelines. We will tweak the Bombay High Court judgment, but we will strengthen the regulations now." The court has now issued notice in the petition and directed a counter affidavit to be filed by the respondents in 3 weeks. The court said while doing so, and I quote, "This court has to consider whether steps taken to frame self-regulatory mechanism need to be strengthened with regard to framework and final orders to be passed." What do you think of the self-regulation mechanism of the NBA? Should the court interfere in the news regulation? Let us know in the comments below. If you found the video informative, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. Consider supporting the work we do here by joining as a member for only ₹89 per month. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.